So I'm hopeful that this might be unique, that I might be the first person ever to give a talk at the law school where the focus is the University of Louisville basketball team and Louis Brandeis. Everything I'm going to say today, I'm not kidding, follows from those two principles. So I hope I've got your attention, either because you're scholarly and you're really into Brandeis, or like me, you love college basketball. So let me start with a hypothetical and explain the University of Louisville side of it. So imagine, I can't really do this with my alma mater, Ohio State, because it's too implausible, but I can do it with Louisville. Let's say that the finals, it's the finals of the NCAA college basketball tournament, whatever, April 1, 2, 3 or so, this coming spring. Louisville makes it to the finals. They're playing Kentucky. Let's make it interesting in the finals. And let's say the Louisville star basketball player, forgive me, I don't know who that is this year, drives the lane. The score is tied at the time, goes up for a shot, is fouled quite egregiously, you'll all agree, by the Kentucky player, and shot does not go in, gets a two-shot foul. So here's the situation. If you're a Louisville fan, score's tied, time's run out, all you got to do is make one of two free throws, and you just won the national championship. That makes for a very good year and very good memory. Let's say the Louisville player misses the first shot and doesn't take the second shot. All right? So we can all agree that hypothetical is utterly implausible. If it happened, it would be a 30 by 30 ESPN special for ages. The coach would get laughed out of the profession. And the reason it's so implausible is if you go back to, I used to coach my kids' basketball teams. I think they started playing about age 5 or 6. But everybody in all of American history that played any organized basketball at all, if they got a two-shot free throw, they took both shots. It's never happened. Second grade basketball, college basketball, and of course, finals of the NCAA tournament, that people would not take the second shot. So it is an unusual thing, and it would never happen, this little hypothetical of mine. But if you find that strange, we have some explaining to do when we shift from American basketball to American law. Because as I can attest from my career experience, I graduated from law school in 1990, so I've practiced for a while, I've been a judge for a while, been a state employee as Ohio SG for a while. I have seen lots and lots of American lawyers not take the second shot. In fact, I don't think it's too bold to say that over the last 100 years, there's not been a weekday in this country where a complaint was filed where someone chose to just take one of the two shots offered to them. What am I talking about when I shift from basketball, where we really get the two free throws, but maybe not so much with American law? The two shots we have in American law come from the fact that every constitutional guarantee we prize, so whether it's free speech, free exercise of religion, equal protection, due process, you name it, whatever it is you care about, you prize, you think it really matters, those protections are dual when it comes to state or local laws. What I'm saying is that the U.S. Constitution, in almost all of these cases, provides a guarantee that applies to that state or local law. That's because most of the Bill of Rights now apply to the states and local governments. That's because the 14th Amendment applies by its terms to the state or local governments. So that's one shot, right? We can all agree. We knew about the federal Constitution. We probably learned that in 7th grade or so. And that limits the state or local government if they pass some egregious law, or a sheriff or a governor does something quite foolish. Well, it turns out, here's the surprising part, that all of our state constitutions, including the Kentucky Constitution, separately protect each of these rights. The reason I can be so confident about that is because the federal guarantees, there's not a single one of these original rights that is truly original. Every single one of them comes from a state constitution. The greatest era in constitution drafting in this country, indeed in the world, is from 1776, it's actually a little before 1776, to the summer of 1787. In other words, before the summer of 1787, when the federal framers wrote the first draft of the U.S. Constitution. Why is that? Because when this country broke, when the colonies, is the way I should put it, when the colonies broke from England in 1776, they had to create their own constitutions for each of these colonies, which had just become separate states. Who were the drafters of these state constitutions? It turns out most of them were the same people that showed up in Philadelphia in the summer of 1787, when, and this is not the way it's usually put, they engaged in a significant act of plagiarism. Every single individual right they created that summer, or they innovated, or Madison innovated for 1791 with the Bill of Rights, when that was eventually ratified, came from one of, and usually many, of the state constitutions. So my point about American basketball and American constitutional law is accurate, all right? Every state and local law in this country is subject protections by that state's constitution, and it's subject protections by the U.S. Constitution, and in most cases, and definitely in the cases we care the most about, free speech, free exercise of religion, equal protection, due process, unreasonable searches and seizures. I could go on and on. You have double protections. Now, so the question is, what in the world is going on? Are American lawyers a lot more stupid than American basketball players, particularly, 5-year-old American basketball players? The answer is categorically yes. It's just absolutely remarkable to me that people do not get this. And I'm going to illustrate this point with a real case and a real person to show that this is not just some abstraction. So there's a case that came out of the U.S. Supreme Court a couple of years ago called Strief versus Utah. Edward Strief is the defendant. It's a drug bust case, pretty run-of-the-mill case, not for Edward Strief, obviously, but run-of-the-mill when it comes to federal unreasonable search and seizure law and state unreasonable search and seizure law. So Strief's busted. He thinks they didn't have probable cause to stop him, or maybe it was reasonable suspicion. I can't remember exactly. But the key thing is he thinks he had no right to be stopped. They had no right to find the fruits of the crime they eventually found. And he wanted to enforce our exclusionary rule, which keeps the fruits of an unconstitutional search out of a courtroom. For reasons of his or her own, Edward Strief's lawyer only raised a federal constitutional claim when it came to that particular arrest. The Utah Supreme Court, which is not I wouldn't call it a super liberal court, I'd call it a moderate to conservative court, is probably what I would say. In a 5-0 decision, the Utah Supreme Court ruled for Edward Strief, so he won. But he won only on the federal constitutional claim. Why? Because they took just one shot. They didn't bring a state constitutional claim. The author of that opinion was Justice Tom Lee, Mike Lee's brother. Both of them are on the Trump list. They're considered good conservatives when it comes to judging, whatever that means. Tom Lee's a very smart judge and a very fair-minded judge. But the decision's 5-0 at that court. It goes up to the U.S. Supreme Court and it's reversed. Quite ironically, the author of the U.S. Supreme Court decision is Justice Thomas, for whom Tom Lee clerked. No loyalty whatsoever in this world. But it was a close case at the U.S. Supreme Court, and you should read Justice Sotomayor's anguished dissent, where she's really concerned about the precedent that's been set. So why am I emphasizing that case? Well, I'm pretty confident, knowing the composition of the people on the Utah Supreme Court, that Edward Strief is in jail at this point because his lawyers did not bring a state constitutional claim. In other words, I have little doubt that the 5 members of the Utah Supreme Court that found a federal constitutional violation, saying it was an unreasonable search and seizure, would reach the same conclusion under the state constitution. In fact, I talked to one of the justices no longer in the court and raised this hypothesis with her, and she said absolutely. Who knows what that means? But I think it's pretty clear. This is not just a missed basketball shot, a missed national championship. This is a person with the ultimate deprivation of liberty staying in jail because their lawyer is not raising a state constitutional claim. My experience as a lawyer has shown that this is really a problem. Now, federal courts, there's some procedural reasons why federal courts don't get as many of these claims, but I've only had one of them now in my 16th year. It's a little harder to get the claims challenging state laws. It's not a problem getting claims challenging city laws or actions by city officials or local prosecutors. And so I've seen one of these. That's a lot of missed shots or not even taken shots. The bigger thing I would say, though, is just to talk to state court judges who would really support what I'm saying, which is that most American lawyers, it's not that they don't take the second shot, they're not even aware of the second shot. So you don't take what you don't know. There was a late 1980s poll in which Americans, we're not even talking lawyers now, were asked whether they knew their state had a constitution, and fewer than 50% even knew their state had a constitution. I hope we're at 100% at this law school, at least after today. That's really a sad fact as a matter of education, and certainly a pretty serious deficit. So that's the problem. That's the Louisville basketball problem, where we know it's obvious you'd always take two free throws if given that chance and they mattered. Why wouldn't you do it in American law? So here's my argument and the argument in the book, and this is what brings me to the Brandeis side of the lecture. The one thing I think most people identify with Justice Brandeis, great thinker, great progressive thinker, great Supreme Court justice, really quite underappreciated advocate. He was a really influential advocate. He's probably the best lawyer in America during the couple of decades he practiced. He's really an astonishing figure in American law. So it's really saying something to focus on the thing he's probably remembered for best. And perhaps I'm a little biased here, but I think this is probably accurate. I think the thing he's remembered for best is this comment about American federalism, which is that the laboratories of experimentation provided by our states provides a wonderful way to develop policy in this country. So what was Brandeis referring to when he talked about laboratories of policy-making experimentation? He was referring, of course, to state legislatures, or you might say city councils, but the basic idea was the policy-making branches of government are the state legislatures, and it's a very good idea for them to experiment. Feel free to experiment boldly. One state gets a good idea, another state can embrace it. Maybe still a third state can try a different approach. If everyone decides after the evidence comes in that it's one approach beats the others, then and only then do we nationalize the approach. That's the Brandeis idea. The whole point of my book, the whole point of what I'm saying today, is to take the Brandeis labs of policy making experimentation and apply the exact same approach to laboratories of constitutional interpretation. So the way I see it is, if we have a situation where there were 51 high courts in this country, 51 constitutions in this country, and the federal constitution and the state constitutions all have lots and lots of overlapping constitutional guarantees, and indeed overlap on the guarantees we care about the most, free speech, unreasonable search and seizure, and so forth, why in the world are we not encouraging our state courts, through our state, through lawyers arguing in state courts, to adopt this exact same approach and try their own approaches to interpreting phrases like due process and equal protection? Well, that is very much not what is happening right now. You already know reason one why that is not happening. A state court can't innovate a new approach to equal protection if no one brings a state equal protection claim, right? You can't innovate what is not in front of you. But the second problem is not a problem that lies at the responsibility of the lawyers or maybe even the law schools. The second problem is the responsibility of the state court judges. The state court judges, most of whom of course were trained, well, all of whom were trained at these law schools that are not teaching state con law, when they think of constitutional law, think of it exclusively in terms of the federal Constitution, which means exclusively the language of the federal Constitution and the language of the U.S. Supreme Court decisions. And what ends up happening is that language, those doctrines, dominate the discussion. So instead of a marketplace of 51 different approaches to interpreting these languages, potentially, you have a complete monopoly where it's one high court at the top, the U.S. Supreme Court, and a monopoly as to what these very generalized phrases mean. So Brandeis would not like what is happening right now. He was a U.S. Supreme Court justice. Maybe he would have liked being at the top of a monopoly. But if you know Brandeis, you know he does not like monopolies. So the odds are very high that that is not true, and he would agree with exactly what I'm saying. So why is it that a state court, given two shots, because the lawyer brings both claims, might think about state guarantees differently from the federal guarantees? Well, one reason is pretty obvious. Many of the state guarantees have different language. Different words lead to different meaning. That's not unusual in law. We shouldn't be surprised by that. just because all of the U.S. constitutional individual rights came from the state constitutions doesn't mean that all of the state constitutions have the same language, and in fact, they don't. For the most part, they're really all over the map. I mean, phrases like unreasonable search and seizure, yes, that basically appears in every state constitution and the federal constitution. The individual right to bear arms guarantees are pretty similar across the board, but there's actually quite a bit of variation from state to state on many of the others. Some states have positive guarantees. You in Kentucky know about the education school funding case here. We had a similar case in Ohio. Partly those cases turned on the fact that the Kentucky Constitution and the Ohio Constitution require the state legislatures to create a thorough and efficient system of public schools. In the words of the Ohio Constitution, I think the Kentucky Constitution is pretty similar. So sometimes you just have a variation in language, which leads to a variation in outcome and a variation in approach, and that has happened. School funding is a really excellent example of that. Sometimes the language can be very similar, but the history behind the guarantee can lead to a different customizing of the language and a customizing of the approach to that language by the state court to account for that history. There could be something unique about a Kentucky guarantee that leads the Kentucky Supreme Court to treat it differently from the U.S. Supreme Court. Obviously, the U.S. Supreme Court can't premise a free speech case based on a Kentucky tradition. They've got to account for the traditions of all of the states and all of the country. The Kentucky Supreme Court is not so limited. Free exercise offers a really easy way to think about this. Think of 3 states in this country that were founded by religious dissenters: Maryland, Utah, and Rhode Island. It should not be surprising if their state Supreme Courts give a more muscular interpretation to free exercise of religion, given those histories. There are 2 other very good explanations for state courts charting their own path, and they should really appeal to law students. I wouldn't say 1Ls, it's a little early to appreciate this, but by halfway through 1L year, you'll definitely appreciate this. So one explanation can be disagreement between the state court and the U.S. Supreme Court based on different methodologies and interpretation. We all know at this point that there are 3 basic ways of approaching constitutional interpretation. There's the originalist approach associated with Justice Scalia and Justice Thomas. There's a living constitutionalist approach, perhaps associated with Justice Ginsburg and certainly Justice Brennan. Then there's the pragmatist approach associated with Justice Breyer and Judge Posner when he was on the 7th Circuit. If you have a U.S. Supreme Court decision that's an originalist decision, and you have a Kentucky Supreme Court where a majority of the members of the court take a pragmatic approach or a living constitutionalist approach, why in the world would they agree? It's really quite absurd. I mean, one of the things that I find most puzzling about looking at state court decisions is how often they lockstep with U.S. Supreme Court decisions that I know for a fact they don't agree with. In about 7.5, I guess it's almost 7 years, I'll turn 65 and I can collect a full pension. Can't wait. One of the things I'm thinking about doing is going out and first being an advocate in state courts, and then, I feel like this has been a lifelong audition, trying to get on a state Supreme Court. And I feel like it would be so easy to run to get on a state Supreme Court, because I know so many state Supreme Court justices in so many state Supreme Court opinions where they are doing things that all of the people in that state cannot possibly agree with. So if you pick a conservative state with a conservative state Supreme Court, and they are, let's say, embracing substantive due process, because why? The U.S. Supreme Court has done the same thing. It'd be awfully fun to run against one of those people and say, do you really agree with that? Do you really think we should have substantive due process in this state? Or I could run in a progressive state where they don't, for example, agree with Citizens United or some free speech decisions of the U.S. Supreme Court, and they will have adopted their approach in lockstep fashion at that court. And I think it would be so much fun to get up there and say, you can't possibly want these people as your judges. They don't agree with, you don't agree with Citizens United. You don't agree with this weaponizing of the free speech clause. So one of these days, I'm really looking for an opportunity to take advantage of what I'm telling you right now. What's very sad is I've got all this great information, I can't use it. You can. You can do everything I'm talking to you about. So my second point, which is really my third explanation for why a state court could disagree with a federal court, is just pure method. Originalists don't agree with living constitutionalists. Living constitutionalists don't agree with pragmatists sometimes. And that it shouldn't surprise anybody when those lead to different approaches and different outcomes. But the last reason is the best reason, particularly for law students. It doesn't take long in law school, particularly after you've been through a few months of constitutional law, to start to get very skeptical that there is one and only one way to approach some of these highly generalized guarantees. Even for originalists. I mean, originalists like to think that it's just pure science, and if you do your originalist principles correctly, out will come something that all originalists will agree is correct. Well, if you look at last term's Fourth Amendment Carpenter decision, you see the originalists all over the map as to what to do with originalist principles and new technology. So the fact remains that we've got a lot of guarantees at such a high level of generality, often with no historical information to tell us exactly how to construe them. And it shouldn't surprise anybody. I mean, this is the pure Brandeis model. It should not surprise anybody in that world where there are no right answers, where you have to be awfully bold to say there is just one right answer. In that world, we should have the Brandeis approach, where the different state courts are taking different approaches to this language and trying out different ways of thinking about it. Even when I was in law school a very long time ago, I was skeptical of the tiers of review approach to equal protection. It just seemed like every 5 to 10 years the court would create a new tier of review. First it was strict scrutiny versus rational basis, and then they were really pushed and they thought, well, we better come up with this other one, intermediate scrutiny. Then we had rational basis with teeth. Larry Tribe, the professor at Harvard, says we now have 7 tiers of review. I mean, that means we're just a couple of years away from an 8th and then a 9th. And is somebody at some point going to say the emperor has no clothes? That just doesn't make sense. That's not a coherent way of thinking about equal protection. So for me, that's just a wonderful opportunity. Instead of letting this monopoly of interpretation, which has led to very goofy doctrine, continue, I say challenge the monopoly. Have a state court say, we're going to try a different approach to equal protection, or pick any other of these generalized guarantees you like, and take a different approach, and maybe see if other states adopt it, a la Brandeis. And maybe if enough states adopt it, the U.S. Supreme Court might at some point say, well, instead of 7 tiers of review, we're going back to 2. Or we're going back to 3, or we're scrapping tiers of review. We're going to do balancing. But the point is, you'd have some interaction, a little bit of knowledge, and it'd be a true free marketplace of ideas on interpretation, as opposed to what we really have right now, which is a federal monopoly. So now the so what? So that's Brandeis. I've linked Louisville basketball. Why do I care so much about this? Let me just give you a couple reasons, and then I'll open up to questions, because I really do care about this. So I'll tell you a story about a constitutional law case that many of you will recognize the name, maybe dimly remember the facts, but then there's a part of the story I'm going to guess you don't know. So the part of the story you know is Buck versus Bell. I think you're going to remember that case. That's the infamous 3 generations of imbeciles is enough. Justice Holmes' majority opinion for the Supreme Court in 1927. At issue was a piece of legislation enacted by the state of Virginia that grew out of the eugenics movement, a really unhappy chapter of social policy and science in this country. What lay behind eugenics was the idea that we could observe that there were people with disabilities. The catchphrase was the feeble-minded, very broadly construed. It covered mental disabilities, but people who engaged in acts of crime, prostitution, couldn't hold a job, the poor. I mean, it was a very broad term. And the gist of the state eugenics laws was that the state had power to involuntarily sterilize the feeble-minded individuals in its care so that they would not procreate and we would not have any more feeble-minded individuals. It's really an astonishing, obviously ruthless movement, and it really makes you wary of the next great idea. But quite remarkably, the U.S. Supreme Court upheld that law in 1927. 8-1 decision. I have to say, sadly, that Justice Brandeis joined the decision, but as you know, he was a progressive, so that should really surprise you. Chief Justice Taft, the key conservative on the court, also joined the decision. The only dissenter was Justice Butler, who did not explain his views. Some speculate that he was a Catholic and that motivated him, but God only knows. He didn't tell us why he dissented, but he did dissent. So that's the part of the story you know. Here's the part of the story that I think you don't know, which is that before 1927, there were 8 lower court cases, 6 of them in the state courts. Of the 8, 7 of the 8 came out the right way, which by the verdict of history, which is to say they invalidated the eugenics legislation, stopped the proposed involuntary sterilization in its tracks. Shockingly, so the heroes of that story are clearly the state courts. The GOAT would be the U.S. Supreme Court. There are 2 really shocking things about this. One, Holmes doesn't mention any of the opinions, any of these lower court decisions in his opinion. Now, some of the state court rulings were on state constitutional grounds, so that partly explains what's going on, but some were on federal grounds. But the more shocking thing, and the thing that is what really makes me unhappy and how non-Brandeisian this constitutional world order really is the reality that after 1927, no one went back to state court. So since you now know about 2 basketball shots, you know what was going on at that point. As a matter of strategy, if someone was going to involuntarily sterilize you after 1927, you couldn't go to federal court and rely on the federal Constitution because we just had a ruling by the U.S. Supreme Court rejecting a 14th Amendment claim. Right? That was off the table after 1927. That's what the Supremacy Clause requires. What was not off the table was relying on a state equal protection, due process, cruel and unusual punishment, or some other state constitutional guarantee. And for reasons of their own, no one went back to state court. Worse than that, Buck versus Bell acted as an advertisement for eugenics legislation, and 15 more states passed eugenics laws soon after 1927. So the eugenics story dies out as the legislation dies out, enforcement of the legislation dies out, not through state constitutional claims in state court, which could have happened. And it's really quite puzzling why it didn't. So there's something wrong with that story. So obviously, thing one is that's a story where the heroes are the state courts. It proves the state courts can get these things right. But thing two about that story, and what's really puzzling, is we think so highly of the U.S. Supreme Court and the U.S. Constitution, we're unwilling to go to state court and challenge legislation that a strategy that actually succeeded for 20 plus years before 1927. So there's something really unusual going on. What are some other good things about independent and vigorous state constitutionalism? Well, it's entirely neutral. It's hard to find something entirely neutral these days, but this one is. I can prove that by saying the biggest federal judge who's an advocate of this, in all time, is Justice Brennan. He wrote a landmark 1977 law review article, one of the top 10 most read law review articles in history. Everything in my book grows out of Justice Brennan's article. I'm a little critical of his article. I think he didn't pitch state constitutionalism in the right way, but everything about the labs of experimentation, the Brandeisian ideas, every single thing I'm saying, he said. And Justice Brennan, if you didn't know this, was a liberal. Justice Scalia, his last majority opinion for the U.S. Supreme Court, a case called Kansas versus Carr, says just what I've said. State courts often experiment in construing their own constitutions in the aftermath of U.S. Supreme Court decisions that are rights restrictive. And then he cites an article promoting everything I'm talking about. When Justice Scalia, so for the law students in the class are here, if you ever come across something where Justice Scalia and Justice Brennan agree on it, the answer is always that's truth. I mean, that will work in the bar exam, that will work on any exam in class, and it'll work for the rest of your life. I mean, sadly, it's not a big set of options where they both agreed. I think it's free speech. There's some good criminal procedure cases. I should be careful about that. There's quite a few criminal procedure cases. But this proves that's truth. That's very much truth. So the other, let me try to put this, and maybe this will be how I conclude and start taking questions. One way to try to think about this topic that I think is healthy, and I hope will make it a little more interesting to you, is try to think about everything I'm saying in the context of U.S. Supreme Court decisions of the last term or even the last couple decades, and particularly the ones you care the most about. That's really the way to help you think about this. So let me give you a couple examples of cases to try to put what I'm saying in context. So one case that came out last term, it was really turned out to be a non-decision, is Gill versus Whitford. So this is the political gerrymandering, extreme political gerrymandering litigation that's been going on for quite a while. There was a prior effort in a case called VF to try to create a constitutional principle that would limit legislatures engaged in partisan political gerrymandering. Most of you, I think, probably know the U.S. Supreme Court. Duck seems a little unfair, but anyway, they didn't resolve the issue in Gill versus Whitford. So that's a situation in which the U.S. Supreme Court has stayed its hand. All right, it's not announced a rule that everybody has to follow. It's stayed its hand. So for now, and that may change, that could change in the future, but for now, the federal Constitution really doesn't have anything to say, at least when it comes to U.S. Supreme Court precedents. So that means all 50 state courts, all 50 state legislatures, states with initiatives, can enter this fray. You had a Pennsylvania Supreme Court decision last spring where they relied on their own state constitution to announce a rule when it came to limitations on the legislature when it comes to political gerrymandering. My state, Ohio, passed an initiative where that's where people propose something and then the people vote on it, so it doesn't go through the legislature. It's obviously not a court decision. But this initiative came up with an approach, and no one would say it was perfect, but it is something Republicans and Democrats have both been willing to live with, number one, and number two, everyone agrees it was a big improvement on what used to exist. So there's an example of something where the court stayed its hand, and all the states can enter the marketplace. We can see what happens. It's quite possible if one approach to this develops, particularly on state constitutions, that could influence the U.S. Supreme Court down the road, if that's what people think is a good idea. Or if they stay their hand, maybe that, it's possible the state courts and federal courts stay out of it because legislatures and initiatives slowly fix it, although everyone would have to agree this is going slowly. Carpenter's the case I mentioned just a little bit ago. It's a Fourth Amendment case. It obviously involves this whole problem, the cell towers, and how much does it matter that we've given away information about where we are through our cell phones to third parties, and does that mean the government is entitled to the information? It's a really difficult issue. I don't think living constitutionalists, pragmatists, or originalists say there's just one way to look at this, and I think everyone would agree it's quite difficult. Well, the U.S. Supreme Court's decision in Carpenter does not answer everything in this. It does, Carpenter does win, at least at the court. It does announce a Fourth Amendment rule, but it's a rule that leaves an awful lot of experimentation for the states. I should point out that this idea, it's called the third-party doctrine, that the U.S. Supreme Court did not apply to cell phones. Many state courts had innovated that exact rule in the decade or so before Carpenter. So that's an example where the states were taking the lead. The U.S. Supreme Court followed that lead and modified the third-party doctrine to account for this new type of technology. And in the future, the states can continue to take the lead as we try to fill in some of the gaps left by Carpenter. So then you have other cases where the court constitutionalizes the area. In other words, they announce a constitutional rule. So if we focus just on the last term, a very big case was Janus, the union case. But I mean, pick your case. I mean, liberal or conservative, all it has to be is a constitutional ruling. And just remember what that means. What that means is the U.S. Supreme Court has now occupied the field, and there really isn't a lot for the state courts to do. I mean, they can say they disagree under their own state constitution, but for the most part, once you have a nationalizing constitutional ruling, and Janus is a broad constitutional ruling, there's really not a market anymore. That doesn't make it wrong. That's not my point at all. I'm just trying to say, as you think about U.S. Supreme Court decisions and U.S. Supreme Court debates, try to think about it through this lens, and I think it'll really make a difference. So I've got a bunch of other things I can say, but maybe I'll have them go through the questions. The one thing I'm 100% confident of, I don't know if Brandeis is much of an athlete. The fact that he's so well read and such a great lawyer, I'm frankly not optimistic. But actually, that actually makes it even easier for me to say categorically he would have taken both free throws because he would have missed the first. So he would have needed. So had he been playing in that championship game, he would have taken both. I think I'm not sure you guys would have won. Actually, that's the bad part of it. So be it. But anyway, I'd love to take questions on anything I've said or anything what seems somewhat related to what I've said. Yes?
There was a
sort of 3 times.
I know you. I was just gonna say, I know you've been asked this question before, but I'm still a little confused. So.
Yes.
I'm on board with your argument that this approach is neutral from a Republican-Democrat perspective, because sometimes the government will do something Democrats like, and then courts may or may not invalidate. Some government will do something Republicans like, may or may not. But it doesn't seem like it's neutral in terms of more of a libertarian perspective. It seems like it's a recipe for the government losing more often. Yeah. So, you want me to spell? Are you on board with this, or do you want me to spell out my argument?
Why don't we do this? Because I think there's nothing students like more than 2 people that are arguing with each other. It's so much more interesting, right? So I'm not saying that's what we're going to do, but I think it's really great for me to respond to your first point, and then you can push back. So I think everybody knows what libertarian means. I mean, so libertarian is just, skeptical of government power, right? And libertarian's a funny word because it applies to conservatives and Republicans sometimes, and liberals and Democrats sometimes, but it's a very good word in this debate, so it's a great word to use in this discussion, because in one sense, you're exactly right. What I'm promoting is highly libertarian. In other words, and so not neutral when it comes to this really substantial debate in government of limits on how much power does the government have vis-a-vis the individual. And the reason why what I'm saying is super libertarian, my cards are already out there to show it. If what I want is for us to leave a world in which we only took one shot at knocking out state and local laws, and I'm giving you 2 shots, and I want you to take those 2 shots, the outcomes are going to be, by definition, more libertarian, which is to say more limitations on state and local laws. So I think it's quite right that if I had my way, and I think if Brandeis had his way, and Scalia and Brennan had their way, where we took state constitutions seriously and took the state second state shot seriously, it's probably accurate to say over time that would lead to more decisions invalidating state or local laws. I think that's probably an accurate assumption. It would probably mean, for what it's worth, just to pause there, because I think it's a little complicated, I think it would mean, I know it would mean, a lot more state court decisions doing this and fewer U.S. Supreme Court decisions doing this. So that's a very important distinction, because if you want to ask why this federal judge is so motivated here, is because I'm terrified about the path we're on when it comes to the U.S. Supreme Court. I mean, and this is just worth emphasizing for a second. The path I see us on is a path where it just seems over time, at least, I started law school in 1987, it just seems like the path is not, are you restraintist or not restraintist, are you libertarian or not libertarian? It's there are blue rights and red rights, and one group gets this right, and then the other group gets this right, and it just keeps going up and up, and the stakes at the U.S. Supreme Court get higher and higher, and our debates about confirming justices get more and more fraught and more difficult. That's a very scary world to me, but it's an understandable world because the power the court's exercising is really significant. These are winner-take-all debates, and if you take over an issue, occupy the field, sideline an opponent, people should really care. In my world, those winner-take-all debates aren't as urgent. They don't have to happen as often. In other words, the court doesn't have to take a winner-take-all position. In fact, can sometimes stay on the sidelines because you've got vigorous protection at the state courts. So, while I quite agree with the point that this is libertarian, it's not obvious to me what that means in terms of which courts are invalidating things. So now my second response, so this is confession and avoidance. So I'm confessing to agree with you that this is going to lead to more, and he's doing this because he knows I'm a restraint-driven judge. I don't like judges running the world. So if I don't like any judges running the world, I just prefer state judges to run it, not federal judges. But my second thought is we shouldn't jump to the conclusion that if we have a pure Brandeis model of people being able at the state court level to disagree about words like due process and equal protection and what they mean, that doesn't force you to go up and be more protective. Nothing about what I'm saying suggests the best state courts are the ones that are more protective than the U.S. Supreme Court. I really think it's quite legitimate for a state court to get up and say, we're less protective on that issue. The Kentucky Constitution just doesn't have this feature. So Citizens United is a very controversial issue. It's a decision progressives don't care for. Conservatives are much more likely to defend it. I'm generalizing a little bit. But that's an issue where I can imagine a state Supreme Court saying, under our free speech guarantee, it protects speech. It doesn't protect money. And what's going on is the regulation of money in campaigns. That's outside of, say, the Kentucky Constitution's free speech guarantee. Kentucky Supreme Court's free to say that. That's a marketplace of ideas. That's a state court weighing in saying we don't think the U.S. Supreme Court Citizens United decision is correct. So there's a decision where the U.S. Supreme Court's libertarian. It invalidated all this legislation. And a state court is able to say, now I get it that maybe there won't be many state courts willing to do that. I'm not sure I understand why. I would have thought it would be fun to disagree with the U.S. Supreme Court. It seems very empowering. In fact, now that I think about it, this is an audience that would really appreciate that. I thought that was the whole point of federal constitutional law, that the professor would get up there and teach us over the course of the semester just how stupid these federal judges were. I thought if you came to grips, if that was what you understood, then you were going to do very well in the class. So it seems to me quite fun and empowering for state courts to be able to say, this is a hard issue. We respect what the U.S. Supreme Court has said under the U.S. Constitution, but under our unique Constitution, our state, we don't think that's right. So how have I done? I mean,
I'm sold.
Well, now he's being kind. Yes.
As a procedural matter, I am not clear on how you take both bites at the apple in the same case.
Yeah.
Now, my assumption is that we have a state constitutional provision that generally parallels the federal constitution.
Yep.
Are you suggesting that you bring it in the state, have it litigated and then appealed, or do you go to federal and let the federal court decide state and federal issues?
Yeah.
How procedurally do you raise it?
Yeah, so it's a great question. So I'm sure you're thinking of the students when you asked it. Most of the time, when you're going to take both free throws, not all the time, but let's just focus on state laws for a second. You don't like state law, Kentucky law for some reason. Most of the time, you are going to want to go to state court, and you're in that complaint. You're going to the Kentucky trial courts, like the trial courts throughout the country, are courts of general jurisdiction. So in that complaint, you can bring a federal and state claim, and nothing prevents you from bringing a state constitutional claim and a federal constitutional claim. Procedurally, a good state court, Oregon is the best court in the country on this. What a state court would do is it would address the state claim first, and it wouldn't even get to the federal claim if you won on the state claim. The theory being, almost all of the federal guarantees apply to the states through the 14th Amendment. It's usually the due process clause. How can you say that process has been denied to an individual when the state constitution prohibits the state from doing this very thing? So usually, it's almost an exhaustion type approach, although that's not exactly the right term. But the gist of it is that is how you'd go. Now, if you had a local law, so a Louisville ordinance, nothing would prohibit you from going to state or federal court. It's just completely open to you. You just decide, who do I want the final decision maker to be here? If you go to federal court, you run the risk of the federal judges not being as willing to be innovative in construing the state guarantee. Our job is an eerie job to predict what the state Supreme Court would do, and I'm probably the only federal judge in the whole country that would be the one you'd want on that. I would totally go to town. I probably read like 500 pages. First, see my book. Second, see my textbook. Third, but most federal judges are going to be a little reluctant to be innovators. So I think if you're going to take both shots seriously, going to state court is great. And remember, you still get a federal court if you go to state court, right? Because if you raise state and federal claims, you brief them this way, and if you lose all the way through the Kentucky courts on the state claims, and then they reject the federal claims, you can seek cert in the U.S. Supreme Court on the federal claim. So, if it's an innovative, interesting idea, that's a really great tactic. So it really is a possibility. Yeah.
Judge, thanks for being here.
Oh, thanks for inviting me.
It's such a dynamic theory of constitutional law to bring federalism to bear on this. but I'm wondering if there's, and I haven't read the book yet, I'm gonna buy it shortly, and I'm wondering if you
Yeah,
speak
this
to,
is a long line.
I'm wondering if the book speaks to this extra layer of dynamicism that the state judges interpreting text have more freedom to apply their theory of interpretation, be it pragmatism, living constitutionalism, originalism, than the federal judge interpreting the exact same text, because there's a whole body of precedent over on the federal side. And I guess another way of asking that is the state judge, are they really obligated in your mind to incorporate the persuasive authority of federal interpretations, federal interpretations of federal constitutional?
Yeah, I know that. Well, there's a couple ways to think about that. So first of all, they have zero obligation, truly zero obligation to follow the U.S. Supreme Court in construing a similar guarantee in the state constitution. I mean, in fact, if they do that, they frankly do not understand their job description. On a state Supreme Court, their job description is as one member of a multi-member court who is the final decision maker about what that state constitution means. So no Indiana Supreme Court decision, Ohio Supreme Court decision, or U.S. Supreme Court decision controls what the Kentucky Supreme Court does with its own constitution, as long as it independently doesn't violate some other federal guarantee. So that's kind of the first order of business. I think the fact that so a lot of state court judges are elected, and I think sometimes people think, I can really see it going both ways, that because they're elected, that gives them a little more liberty in construing statutes or constitutions, because if the people don't like it, they don't have to re-elect them. But I don't know what that means in terms of comparing them to federal judges, because I think sometimes federal judges think they have a lot of liberty because they say that's why we got life tenure. And we got life tenure to be completely insulated from the political process. And take a justice like Justice Brennan. He would say, I have life tenure so that I can construe the federal constitution in a muscular way and protect the individual versus the state every chance I get. So I think you can look at it both ways. I mean, I can't prove this, but my hypothesis would be that over time, generalizing, I would say the federal judges have been less faithful to the language of the U.S. Constitution than the state court judges have been faithful to the language of the state constitutions. In other words, if there was some way to try to prove what I just said, that's my prediction of what the answer is. Do I know that to be true? I don't. The other thing which enters into this really interesting idea and question is what role the amendability of the state and federal constitutions has when it comes to interpreting. So I don't think it's an unfair generalization to say that the U.S. Constitution is very difficult to amend. It takes 3/4 of the states. And that difficulty of amending it has put an awful lot of pressure on the U.S. Supreme Court at various times in American history to what I would say effectively amend the Constitution by interpretation. So I might say that about the 1930s decisions, increasing the power of Congress. But the point isn't that I'm right about that. The point is it's very difficult to amend this. And for people that think it's very important for the Constitution to reflect modern norms, which we have schools of thought that think that's right, you can see that dynamic affecting them and saying, well, if we don't do it, no one can. At the state level, it's a very different dynamic because most state constitutions can be amended by a 51% vote. A third of the states have initiatives where the people can just, a group of citizens can just, they get enough signatures, put on the ballot, let's change the Constitution to say X. So you could see, but then it cuts both ways, right? The state court judge could say, I'm not going to touch the language, because if they don't like this, they can fix it. But he or she could say, well, I'll do what I want, because if they don't like it, they can overrule it. I mean, so I could see it playing both ways. But if I had to guess, I would say the state court judges have been more faithful to the language in their constitutions than the U.S. Supreme Court has, and it probably goes to amendability. Yeah?
Thank you so much for coming.
Good to be here.
Something makes me nervous about your argument, though. And I think it's fine if we're talking about the state constitution giving more rights or reinforcing what we do on a federal level, but do you have any concerns about experimentation with rights that could contract on the state level? That's one. And then the
Yeah.
We've seen a rise in voter initiatives, so we're voting on First Amendment, or we're voting on equal protection, and then people in the state realm say, well, this should be a lot less, and if everyone in that particular state says fine, that sort of reaffirms their political ideology. But what about the impact on maybe discrete and insular minorities, or the historically oppressed, or the color, LGBT? Where does it end, and where do you find your faith that the state system will be an appropriate place for us?
Well, I not only could talk about this for 2 hours, I would like to talk about it for 2 hours. I mean, this question goes to the heart of the whole thing, in my view, and it helps explain why state courts aren't taken as seriously. It helps to explain why there's been less of this. It helps to explain why we trust so much more the federal courts and the U.S. Supreme Court and the U.S. Constitution, which I think is all, the erasing of Plessy with Brown, and that's just such a part of our American legal story. So do I really want to fight against that? And the answer is no. I want to supplement that story, and I don't want us to forget what happened, but I don't want to be captives of the past either, because I really wonder if this point, and this really motivates me, this point in American history is a very good time for us to unleash states as labs of experimentation, not forgetting what's happened in the past, but hopefully learning from it and showing, as the Buck versus Bell story showed, that they can actually come out the right way. But let me illustrate this by not talking about me, but by two scholars who, have way more credentials on exactly your question than I do. So Bert Newborn is an NYU professor, and he's a civil rights litigator. He wrote this article, I think it might have been the same issue as the Brennan article in 1977, and his article was called The Myth of Parity, which gives away his thesis. His thesis was Give Me a Break. He didn't know me then. I don't even think he knows me now. But it was, there's no way elected judges at state courts are going to be as rights protective and look after discrete and insular minorities in the way federal courts will under the federal Constitution. And so that's what he says in 1977. And then William Rubenstein, Harvard law professor, this article's at Harvard, neither one in Louisville, so they're not that good articles. But anyway, but this one is 1999, 1998, and William Rubenstein and Bert Newborn have the same worldview. All right, they're both very much engaged in civil rights. They teach civil rights and they practice civil rights. They're very much involved in lawyers. And his article gives away his thesis, and it's called The Myth of Superiority. And he says his testimonial was, hey, I've just spent the last 20 years litigating on behalf of gay rights, and we always wanted to be in state court. And the state courts were the place to go. And he does this in 1998-99. This is before Goodrich, which is the first gay marriage decision. So, I mentioned this in the book, but that's another story where the U.S. Supreme Court's the one that shut that door in 1972. They shut it again in Bowers versus Hardwick. Kentucky Supreme Court, by the way, is an example of a state Supreme Court decision that did not follow Bowers versus Hardwick. That Lawrence, which overrules Bowers versus Hardwick, cites the Kentucky Supreme Court decision. But Rubenstein, relying on the post-Bowers cases, relying on the post-Baker case, says all of our victories came to the state courts. And he says that in the late 90s. Of course, the first gay marriage decision is Goodrich, the Massachusetts highest court SJC decision in 2003. That leads to other state high court decisions, leads to state constitutional amendments, state legislation. There is no Obergefell without Goodrich. There's no other way to tell that story. The idea that was going to be fixed through the federal courts alone is just not accurate. So what it seems to me is my real answer to your question is it's complicated. And all I want lawyers to do on behalf of their clients, because this is a big responsibility to fix someone else's problems, is think about both free throws. That's all I want them to do. If you're in a state court where that state court is not going to entertain that right, well, don't take a second free throw. That's just throwing it against the backboard. Nothing's going to happen. But at least think about it. And then if you're with an interest group, think about the big picture. Think about how you do this. You know, institutional litigation is not about just one case. It's about how you achieve a goal over time. And I guess if you're thinking about these individual rights cases that way, I just don't know how state courts and state constitutions aren't part of that conversation. And I think so. Yeah, it's not going to work for every case and every issue, but I think and the reason it's not going to work for every case and every issue is it's entirely neutral, and you're going to get rights restrictive, you're going to get rights expansive, and that's just what's going to happen. I wish I could tell everybody to work out just the way you want, but that's not going to be right.
Thank you for a very thought-provoking talk. I haven't thought this hard for a long time, just trying to grapple with the ideas. I know I'll be expected to say something about Brandeis because I'm sort of the resident Brandeis person, but he was probably more athletic than you might think.
Oh, yeah, that was unfair. That was unfair.
He
I was thinking I had something over him.
Well,
I know I don't have brains over him, but I thought I was a better athlete.
But he canoed and he rode horses, horseback riding. But I would probably agree he probably didn't make the first shot. I don't think he was that kind. But what he would do is he would find everything there is to know about basketball because he always got the facts.
Yeah, no, that's his briefs.
Yeah.
Yeah, that's his Brandeis briefs and everything else. Even pre-Brandeis briefs, he was writing
yeah.
Brandeis briefs. Yeah. Other questions? These are all great questions. Oh, go ahead.
Did you have someone else?
Oh no.
I mean, these have been great questions. It'd be great to get a couple student questions.
Yeah, no, students. Yeah, come on, ask me a basketball question.
Yeah.
Urban Meyer. I can take anything.
I'll put my students on the spot because I know I have some 1Ls here. I see 2 back there and a couple here.
You guys are lucky.
Our questions are so, they're so basic. I'm like, wait a minute.
Ask your question. Ask your question.
There's no such thing as
it's a bad
How could it be bad? It can't be bad.
Tell Judge Sutton the oldest written constitution still in existence.
Massachusetts.
So I actually want to. So I'm going to learn from you right now, because I want to be reminded of that. Is am I right? Is it the oldest? I mean, so the states have all these fights. The reason every time I give this talk, everyone thinks they have the oldest constitution. And am I right that the Massachusetts one is the oldest one because it goes from like the 1600 Royal Charter?
1780.
1780. Is that what I'm remembering? Is that right?
They think they're right because they're under the mistaken impression that because I told it to them.
Oh yes, everything he says is true. Everything he says is true. Well, there's a lot of fun. I mean, so one of the things that amused me in looking in this, several state constitutions were written before July 4th, 1776. Talk about presumptuousness. And talk about treason. I mean, they haven't even declared their independence, and they're out, at the bar writing their constitution. I think New Hampshire was like January of that year. It just seems so ahead of the game. But anyway, that's how they get into this who was first thing, and everybody thinks they're first. But it is the Royal Charter thing. I think that's their theory, because I think their new constitution post 1776 is not that close to 1776. I think it took a while.
This is not our theory, by the way. This is what we have been taught.
Well.
So we have to.
Yes.
This question may make sense or not, but
I'm sure it's a great question.
You talk about the Supreme Court having a monopoly on, what the federal Constitution means.
And what these words mean. Yes.
Yeah, right.
Yes.
But wouldn't you say that as a circuit court judge, you all weigh in, and then they take, up the issue?
That's an awesome. What year are you?
A 3-0.
That's a great question. It's such a great question, and it dignifies my job, which so rarely happens. So you're quite right. So let's just make sure everyone gets how good that question is, because I was saying there's a monopoly, and it's just the U.S. Supreme Court versus these 50 high courts as to what due process, equal protection means, and you're making this great response. Well, it's not really a monopoly, because before the U.S. Supreme Court decides, even under federal law, the lower federal courts weigh in, or as they call it in the Constitution, the inferior federal courts. I hate that word. It's bad enough that we're lower courts. I mean, call us inferior? Seriously, they didn't have to do that. But it's true. We all can weigh in on these issues, and then the U.S. Supreme Court eventually can resolve the circuit split. So you are right that is a bit of a marketplace. Now, So yes and no. But if Justice Brandeis were here, and he said, wait, your free marketplace is everybody gets to tell one company what they think that one company should do, and then that one company controls the market after that?
Yeah.
Oh, he'd have been really excited about saying that's an antitrust violation. So so I think it's a really great point, but the fact that they're that have the final say is to me quite problematic, and I think I truly think it has hurt American constitutional law. I really think we'd be better off across the board with more debate on these things.
Jeff, we had another student question.
Yes, yeah, can't wait.
Did your philosophy with interpreting the Constitution, I mean, did it evolve over law school and your career after, or did you kind of bring a set philosophy that you kind of carried with you? I mean, and I guess what mostly influenced your interpretation as you grew up?
Yeah, that's a great question. So I was so uninformed. I can't emphasize enough how uninformed I was. The reason I start with basketball analogies is I thought I would be a professional athlete for 22 years. Look at me. That was like the stupidest thing ever. And so I spent so much time. Finally, age 22, I tried out for one team. Like, you're never going to be a professional soccer player. You've got to find something else. So I had no idea about any of this stuff. I couldn't have named probably one member of the U.S. Supreme Court. I would have been one of the people that didn't know my state had a constitution, knew how many basketball teams they had, and how many soccer teams. I did not know that. So when I got to law school, I was what every law professor loves, a blank slate. I just didn't know anything. Now I will say what happened to me in law school, and I was not politically conservative or liberal. I was just like more interested in other things. That's really the unfortunate truth. But I will say in law school, in con law, I was not happy with con law. Because I was looking for coherence, and I just wasn't seeing it. And then 3L a year, my father-in-law, who was a lawyer, gave me Bork's Tempting of America, which is a book of Robert Bork he was actually, the Kennedy seat was filled after Robert Bork was first nominated to fill that seat. It was Justice Powell's seat. And he lost in a pretty big way, like 58-42 or something. And so my father-in-law, who was not really a political conservative either, and he was a tax lawyer, so I don't even know why he gave me this book. But I really thought his views of originalism just made a lot of sense to me. Now maybe what was happening was I was just frustrated, like I couldn't connect the dots, because what you're thinking about is not am I an originalist or living constitutionalist. You're thinking about, I want to learn this. I want to be able to tell the professor I've learned it. And it's always easier to learn things that cohere. It's very hard to learn things that don't cohere. And so that was just super frustrating to me. And then Bork gives me this theory that, well, that makes sense to me, that words don't change, and what they meant they always meant, and if you don't like it, amend the Constitution. That's a very abbreviated, perhaps unfair summary of it, but that really connected with me. And then when I clerked for Scalia, that just really messed me up. Then I really became an originalist. Then it was all over. No, but I love, actually, that's really glib and inaccurate, because the thing about Justice Scalia was the very best thing. It wasn't learning why he thought originalism worked. It wasn't learning why he liked textualism. It was that he never had a bad day in law, because every law problem was so much fun for him. I mean, you could have this just like dry as dust ERISA case, and you're just like, oh, here we go again. And he'd just be so energetic, as if it was Marbury versus Madison. And that was like the greatest gift, to start to think like that. Now, it's not healthy for interpersonal relationships, but it makes this profession so much fun. So that really affected me. And I think he's such a independent thinker, and just always thinking there's got to be some way to do it. That, I'm not saying I have that ability, but I definitely find myself constantly, because that's just the way he was. He always was thinking. It's really hard to emphasize enough how much fun. It didn't matter whether you were liberal or conservative. He was just so energetic and passionate about what just seemed like the stupidest things. And then before you knew it, you were just doing the same thing. It's really quite unfortunate how a life can turn. But it really made a difference.
So with your philosophy, which is inherently leaning libertarian, I guess, if the nation were to move forward...
Probably not, for what it's worth, but
yeah,
keep going.
Just slide that in, maybe. if the nation moved forward with that, what secondary effects do you think would have on like political, like the party system?
If we got more libertarian, So, well, I mean, that's a really interesting political science question. What's complicated to me about it goes back to something I was saying earlier, that libertarian doesn't necessarily compute to one party or the other. So there's sometimes a libertarian proposal is very much associated with one political party. That's just the way it is. And other times there can be something that's just as libertarian that's associated with the other party. So, I mean, I'll just try to come up with the top of my head 2 very controversial topics. Capital punishment is something that, is obviously has a big libertarian component to it. I think it's unfair to say all Republicans are for capital punishment, because, gosh, we only have about 15 states doing it, so that can't be right. But on balance, you're probably bound to see more Republicans supporting it than Democrats. But that's just a very libertarian debate. What's the role of the state in here? Now let's talk about abortion. What's the role of the state on that? And that one, you'd probably say you'd have a greater number of Democrats. Again, you can't generalize here with a view about it. So I guess my real answer is I don't think it affects the 2-party system. I mean, it doesn't worry me. Let's put it that way. I mean, I'm not exactly thrilled with the 2-party system right now, but I don't. I mean, so I guess what you're thinking is it's Brandeisian, that we'll have more competition. Is that where you're going?
Yeah.
I see that idea. That's a really good idea. Yeah, you might be right. Yeah.
How about last question here, Judge?
Yeah.
First, I want to thank you for coming out today. I'm a 1-up. I'm somewhat libertarian myself, but I do have some concerns about the application of your theory. How do we know that it won't end up producing another outlet for polarization? That's one thing that I'm kind of concerned about, that it won't have the libertarian results that we might hope on the practical level, with rights on both sides of the spectrum really contracting in different states.
Yeah, so I really hope you're wrong about that fear, because I'm very motivated by the idea that we are really polarized, and the last thing I want to do is propose something that is another outlet for more polarization. That doesn't seem to me like a great accomplishment for an American citizen in 2018. But I'd like to think it's really quite the opposite, that these winner-take-all debates at the U.S. Supreme Court, where Americans care deeply about them, and Americans love judicially enforceable rights. We just have a very hard time agreeing about which rights to enforce, and that's what leads to this winner-take-all debate phenomenon. Well, my hypothesis is that there's some areas where there really are just regional differences in America. So when is it, think of it, this is a political science way to think about it. When is it that a majority of Ohioans, should tell a majority of Montanans what to do? When should a majority of people from Wyoming be telling people what should happen in New Jersey? I think we should ask that question a little more often. And we should be a little skeptical about it being our job to tell our neighbors what to do with themselves. Let's focus on what's at home, our community, our city, and our state. And yes, there are some national bedrock guarantees, and if they're in the U.S. Constitution, they're enforced there, of course, great. But as to new, more innovative ideas, I say pay a little more attention to your own state, and if it reflects a dynamic and a history and a culture in that state, that's great. I actually think it'll be the opposite of polarization. But I think what's polarizing is our insistence on being busybodies, telling other people what to do. We should be careful before we do that, and maybe be a little respectful of our differences.
So that's a good note to end on. I think, Judge, it's a sign of the appeal of your talk that this was sponsored both by the ACS, the American Constitution Society, and the student chapter of the FedSoc. So thank the Federal Society. So thanks to both of them, and also sponsored by the Dean's Office.
Thanks. Yeah, thank you to all three.
And we have a reception up in the Mosaic Lounge right now. If you want to pigeonhole the judge and talk to him a little bit, get copies of his book if you like. And thank you very much for being here.